of the day number 3.
Prisoners and Victims Claims 2012 Expiry and Applications Date Amendment Bill, Committee stage.
I declare the House in committee for consideration of the Prisoners Victims Claims 2012 Expiry Application Dates Amendment Bill. Mr. Chairman.
Hang on. Leave's going to be short for one question.
Okay. In that case, we'll maintain that version.
Right. Members, the order. Members, the Housing Committee on the Prisoners and Victims Claims 2012 Expiry and Application Dates Amendment Bill. Point of order, Louise Umston.
Thank you, Mr. Chair. I seek leave of the House for this to be debated as one question.
Leave is sought for the all provisions of the Prisoners and Victims Claims 2012 Expiry and Application Dates Amendment Bill be taken as one question. Is there any objection to that course of action? There is no objections. The question is that parts 1 and 2 and clauses 1 to 3 stand part. Charles Cheval.
Thank you, Mr. Chairman. Mr. Chairman, I think it probably is a sensible decision to take the bill as one question in the committee. It is a short bill. I just want to say a few words so that those listening and that members who haven't had the benefit of sitting on the Select Committee just do understand the context of the legislation. Back in 2005, Parliament enacted the Prisoners and Victims Claims Act, and this was in response to widespread concerns about the order by the High Court in a case referred to and reported as Tonoa, where an inmate sued the Crown because he had suffered what the court decided was an abuse not only of his physical well-being but of his human rights through the application of what was known at the time as the BMR, the Behaviour Management or Behaviour Modification Regime operated by the Department of Corrections. And so what happened is that the High Court said on this occasion that the inmate was entitled to a substantial award of damages to, in part, indicate that the behaviour of the prison officers concerned, sanctioned, it seemed, by the department, was not to be condoned by the court. Now, there was real concern at the time about the position of those who had suffered loss, physical or otherwise, as a result of the misdeeds of offenders who were serving in prison but who might receive a windfall payment of compensation through the application of the precedent in Tonoa. And as a result of that concern, the 2005 legislation was enacted. Now, the 2005 legislation, as can be seen on its face, was always intended to be temporary in effect. There are 2 sunset clauses in that Act, and Part 1 of the bill before us in committee today, Mr. Chairman, would extend one of the sunset clauses. Part 2 would extend the other for a period of 1 year. Now, the reason for this extension was canvassed in the second reading debate. There was, as is known, a change in Minister of Justice between the previous election and now. And for whatever reason, the order paper was not in sufficient order to see the legislation that was proposed to replace the 2005 Act brought through all of its stages in order to be enacted. When that became obvious, the Minister of Justice approached, as I understand it, a number of parties and said, well, what do you want to do with this legislation? Do you want it to expire, in which case there is a real risk of that? Do you want it rushed through the House? Or is there some other way that we could deal with this, for example, by a short extension of the current provisions of the legislation? And my colleagues and I discussed the issue. We couldn't see that it would be just as far as the victims of offending was concerned to simply allow the existing regime to lapse. And so, although we would have preferred a considered discussion of what ought, if anything, to replace the 2005 legislation, we were, in the end, agreeable to a short extension of its terms in order to allow that careful consideration of replacement legislation to occur. So, sir, that's the simple background to the bill that we're considering. 2 extensions of the relevant sunset clauses for 1 year only to 1 July 2013. Now, as to what might happen after 1 July 2012, it's my hope that we will get some sensible discussion, both inside the Justice and Electoral Committee, but also hopefully between spokespeople, about what ought to be the replacement model for the 2005 legislation. In respect of that discussion, Mr Chairman, it seems to me that we need some information to be put on the table. First of all, how much use has been made of the existing, Mr Chairman, how much use has been made of the existing legislation? To what extent have the victims of offending found it a useful tool to try to make themselves whole as a result of having suffered loss through the wrongdoing of people who then ended up in jail, have themselves won damages, and then had some of those damages go to their victims? The figures, I have to say, sir, are a bit disappointing. Although the Minister wasn't initially willing to disclose them, she made some disclosures in her second reading speech, and further disclosures were made during the estimates process by the Department of Corrections, so that we now have a relatively full idea of the extent of the use of the Act and of the contingent liabilities that accrue to the Crown as a result of potentially pending claims. And frankly, it's not a particularly compelling picture. That's not to say that this wasn't the right thing to do at the time, but that is not the question before the committee and perhaps later at a third reading stage the House. The question is, what ought we do now with this legislation? And my colleague Phil Goff made, I think, a compelling point in the second reading debate. That is, if we are going to rethink this from the perspective of the victims of offending, without violating the human rights record of our country or of those who serve in our prisons, serving sentences in our prisons, how best should we do it? Well, first of all, what logic is there in restricting any ongoing legislation simply to those who are sentenced to a custodial sentence? What about community-based sentences? Why should people who simply manage to avoid jail be able to avoid having to make some sort of payment to their victims in the event that they receive a windfall payment at some point during their sentence? That just doesn't seem to be logical. Secondly, why should the windfall payments be restricted to payments from the Crown to the offender? What about if the offender somehow gets some enormous payment from a will, or from a lotto win, or from some other means? Well, why should the victim of their offending have to go through the ordinary processes of suing in the court, all the expense, all the trauma, all the delays that we know are inherent in civil litigation, in order to try to recover something to recognise what they've been through? So I think this rethinking, sir, needs to happen. And if we're to support something going forward, it needs to be based on principles. It needs to be based on the idea that victims are entitled to recover something if it's possible to make a recovery, and that they should be able to do that without having to go through the hoops, as it were, of the legal process. It shouldn't matter, as I say, how that money becomes available. If it's within reach legally, as it were, it ought to be reachable. But the second principle, and the most important counterbalance to that, is obviously what we've learned as a result of observations from human rights bodies and other experts about the operation of this legislation. Can we balance those considerations and what is an important factor for New Zealand, our very proud record of preserving and protecting human rights on the international stage, while maintaining a regime in this sort of area that does look after those who suffer from crime or their families. And it's that balancing act, sir, that this bill will only give us a year to consider. We have assurances from the Minister that we will be able to perform that exercise adequately. Really what I want to do in conclusion in this speech is give very clear notice that we'll be holding her to those undertakings.
The Honourable Phil Goff.
Mr. Chairman, I'm pleased to take the opportunity